Hi, good morning. This is Ruby Powers with the Powers Law Group. It is Friday, January 26, 2018, and this is our weekly Facebook Live Q&A and update from the week. So first off, we just to let you know that we are a Powers Law Group in Houston, Texas, but because it's federal law, we can help people all over the world in U.S. immigration law. And if you have any questions while we're proceeding, for about the next 20, 30, 40 minutes, please give us a call at 713-589-2085, 713-589-2085, or you can also make a note on our on the comments section. And we also can email at contact@rubypowerslaw.com. So let's go ahead and get started with the recent updates. So I'm making sure everything's good. All right, so what's been going on? Well, it's another week in the immigration world, and so we all know about January 8th. We had the one last renewal of the TPS from El Salvador, and then the next day we had the ability to do DACA renewals. And so right now that is still the case. You can do a DACA renewal, and so that would only be if you've applied within 150 days. Your card's about to expire. Your DACA is about to expire within 150 days. That would be about June 25th, 2018. So if your DACA is going to expire between now and June 25th, 2018, then you can, if all things being equal, you still qualify, you can apply for a renewal, but you've got to get it in right away, because the litigation to challenge that ruling is imminent and will be happening probably any minute or day now. So keep that in mind. If you do have a consult for DACA renewal, you probably need to be ready to file the same day if you're eligible. And so actually what's really on everybody's mind is the most recent news from yesterday, which is today's hot news. Here we have a recent New York Times for today. What we know right now is that we did have a government shutdown on Monday, January 22nd. Right. And because the government couldn't make an agreement on how to, for a spending bill. So they did make an agreement for later on in the day and for about another 3 weeks, which is until about February 8th. And so they're negotiating. One of the key points in the negotiation is DACA Dreamers and the wall between Mexico and the United States. So yesterday, the President Trump proposed legislation that would provide a path to citizenship for as many as 1.8 million young undocumented immigrants in exchange for an end to decades of family-based migration policies. So a costly border wall and a vast crackdown on other immigrants living in the country illegally. We don't have the specifics. What we do know is that on Monday, so that would be January 29th, I believe, we will have an update. It'll be a press conference as to more of the specifics. And later, what will happen is they'll announce more details so that we can start dissecting what their proposal is. Now, this is a proposal, and they're negotiating with Congress for the border wall. And so because they have to make a decision by February 8th, or there will be another shutdown, the negotiations are very hot right now, and that's why it's critical. That's why everybody should be calling their congressman or senator and talking about what is important to them. And that is why this is important, because this might be this one time where we can potentially get some type of change. Now, I don't know all the details, but part of what the proposal includes is to get rid of diversity visas. They call it the diversity lottery visa. Another part is to get rid of what they call chain migration, which in really cases is family-based migration, where potentially you petition for your brother or your sister, or American petitions for their married child over 21. Now, other things is we don't really know all the specifics, but it is out there, and there's going to be a lot of negotiation going on. So it's important to be an advocate if this is important to you, and making your voice known to calling your senator and congressman. Okay, so we'll continue to update you, and as we find out more, we will be doing more Facebook Lives and posting that. Now, those are the highlights of just this week, and if there's anything that's of interest to talk about, or you have any questions, feel free to ask us. Again, we'll start doing the Q&A. Some of the questions we've already had submitted or we find online or from the calls that we have. So again, before we get started, call us at 713-589-2085, or you can email at contact@rubypowers.law.com, or you can make a note on our Facebook Live chat. So why don't we get started with some of the first questions.
So this question is related to the government shutdown. Will the government shutdown affect my visa application?
Well, USCIS runs on a fee-based system, so that is how they're funded, which means that when you pay a filing fee for an application, that's how they get paid, which means it shouldn't be affected by the government shutdown. But on Monday, we did get notices from the USCIS ombudsman that said that they won't be able to process while there's a shutdown. So I think there's still some components that are affected, as well as Department of State. Although there's fees for that as well, I think that there can be some components that are not in the regular purview of filing fee-based work that can impact the rest of the process. And it was started again like the next day, so it was one day, but we have to see some type of resolution before February 8th, right, which is just around the corner. And it can be impacted by other ways. Another thing is the immigration court was closed on Monday, the day of the shutdown as well. So it depends on where your case is located. But with USCIS, Department of State, Department of Labor, with Immigration Court, with the Department of Justice. So, but it can be impacted in some way.
So the next question that we have is, I heard that it's possible for another government shutdown to occur. Is this true?
Well, it's possible. We could have another one. We had one Monday. This has been a long week, hasn't it? February 8th, we'll find out if they can come to agreement. Hopefully there is an agreement, because this impacts a lot of people's lives. It's also wasteful just to tell people that the government has shut down and have to stop doing certain things. There's a lot of momentum lost, and people's lives can be put at risk. So it is possible, and that's why the next couple weeks really matter.
So moving on to DACA now. I heard that President Trump has a plan that is meant for the dreamers. How can that affect me?
Well, like I mentioned, there was an announcement. So he's not in the U.S. right now. He's in Switzerland at the Economic Forum. But it was announced by the White House in an aid to the media that he's considering a way for 1.8 million young undocumented immigrants, is what they say. That would be a larger scope than just DACA, obviously, because DACA has 800,000 participants or recipients. So they would try to increase scope of the next another 1.1 million undocumented immigrants who would have qualified for the program but never applied. Now, that's an interesting point. So anyway, basically, to answer your question, this is a proposal. There's going to be negotiation. We're not sure what's going to happen, but this is the time to be vocal. But I like this. This brings to mind, there were a lot of people who were just a little bit older than that June 15 was like 1981 of the age cutoff. There were some people who had come in a little bit later, or there were people who didn't have the proof or who didn't have the right education. So I'm not sure exactly what his proposal is, but there were a lot of people who were sort of on the outskirts of the eligibility, and I still have consults with people who could have applied, or who all they were missing was a GED. And so, I mean, now more than ever, I'm sure that they are watching this closely to see if they would be eligible for what becomes into fruition.
So the next question that we have is, does this mean that we can renew DACA again?
So if you had DACA and your DACA is going to expire between now and June 25th, 2018, so basically between 150 days or less, you can apply if you otherwise are eligible. That means, nothing has disqualified you since you last applied. You should still have a consult and still get reviewed and screened, but basically you can. And if you meet all those qualifications, and you really need to file it now because we don't know how much longer. And that's basically it. Now, do it now. Yeah.
So a question that someone just emailed us is, when is the expiration date for DACA?
When is the expiration date for DACA? Well, I don't really understand that question, but on September 5th, 2017, the initial DACA applications were discontinued, and advanced parole for DACA were disallowed or discontinued. So you were only allowed to do a renewal for 1 month. And then that left all the people who were eligible for renewal from October to now not able to renew. But now, because of that announcement about a week and a half ago, people can. So if you are within the 150 or less days and otherwise qualify, you can renew.
So someone just asked, why is it taking so long to process my applications?
Okay, well, how long does it... It depends. To answer that question, you have to know which application are you talking about. Where is it located? Are there any complications to that? So just to answer it in general, you can go depending on where what application it is and where it's located. Let's say it's with USCIS. You can go to USCIS.gov and go to their website and click around. Basically, around the bottom, there's a place that says processing times. So there's two things you could do. You could put your receipt notice in under the case status and see what's going on. It could say, we received, or we issued you a work authorization, or whatever it'll say. And then the other way to use it is to put in the processing times. So at the bottom, you would say, okay, well, this is where my file is located. You can, if you're not sure, you can also figure it out by the receipt number. There's different letters that correspond with a different service, like WAC is for California, or VSC is for Vermont. And then you could figure out what's the processing time for that type. That might be a little too much information, but basically they try to tell you online. Now, another thing to note is that it's not always accurate. So if you find out that your case is outside of the processing time, then you should call the 1-800 number and get a service request, because it sort of helps be the squeaky wheel. And depending on where the file is, it could be at a local field office, and that's a little bit harder to move along. Just for example, in Houston, we have marriage-based adjustments, or most adjustment applications are taking about 12 to 14 months. Naturalizations, I believe right now, are taking about a year. But if you have certain complications, criminal or a lot of extensive travel or things like that, for naturalization, for example, it could cause a little bit longer delay. Another thing to know is that if you have a naturalization application and you've had an interview, so the N-400, you had an interview, the government is supposed to issue an answer within 120 days. There's ways to push that case along if those 120 days have already passed. So it's always good to get a consultation to be able to figure out if that applies to you.
So one question that we keep on getting is that my husband is not on any paperwork like cable bills or lease agreements. How can I prove that we are truly married for my immigration application?
So some cases, proof of marriage is important. And in some cases, people who might have been here don't have any documentation to being here. Maybe they don't have a social security number, or they don't have a driver's license. And so it's hard to get credit. It's hard to be on formal documents. In many cases, people can obtain a tax ID number if they have a government-issued ID from the whole country, get a passport. Well, anyway, what we normally do is we talk to the couple and we try to figure out here's a long list of things we usually like you to collect. And if you can collect, half of it, we're probably okay. You can always add your names to bank accounts or credit cards if it's possible, but if you can't get socials, then that's social security number, then that's probably a challenge. But if you're a member of a church, for example, you could get the membership record or a letter from the church, or you can get the emergency contact at your school listing that you're both the contacts for the children. You can get letters from friends and family. I guess nobody has a Blockbuster membership or any other type of membership. There's lots of different things like Netflix or I don't know. So we think about things, and for example, one other thing about leases, apartment leases, for example, you might not be able to list them as a cohabitant, but in the primary part of the application, but you might be able to list them as someone who also a guest or someone who lives there, so their name is on there. So there's ways to find, and if in worst comes to worst, you can always write a letter about why some evidence is hard to collect to explain that.
So moving on now to TPS. Someone submitted a question that they have TPS and they're from El Salvador.
Mm-hmm.
Their U.S. citizen son turns 21 in June. They're asking, what can I do?
Okay, well, I think I had a consultation like that recently, so this is very common. Well, the first thing you need to do is have a consultation, because we need to see if you ever had any prior deportation or absentia orders, any interactions with immigration, any criminal or any other issues. That's the first thing I think about. The second thing is, did you enter legally at any point? Did you ever apply for an advanced parole? Because we need to have a legal entry in Texas. If you're in some other circuits, you can TPS. By having TPS, it's an admission, so it depends on where you live. But for Texas purposes, if you entered illegally, but you didn't have any problems at the border, and then later on you got TPS and there was no crimes and it was a pretty clean case, if you did get your passport and travel on advanced parole, that you get permission and you come back in, that's an admission. And then when your child turns 21, U.S. citizen child, I mean, if everything else is clean, this is a really nice case here, then that child can petition for you for the green card. But it's probably not going to be that simple. So we have to screen to make sure everything is good all the way through. But if it is, then you could file it with the I-130, the 485, and the work authorization. Is on their pretty much their birthday if you wanted to. And you would get work authorization based off of that within 3 months. And it could take maybe about a year for an interview, but given the fact that you only have about a year and a half left for TPS, that would be perfect timing. So most TPS El Salvador cases, just make sure to get a consultation as soon as possible, because what I'm seeing right now is most strategies are going to take about a year to 2 or maybe more to put in fruition, and we only have about a year and a half left of TPS for El Salvador.
So another question regarding TPS is, they say, I have absentia deportation order, and they're wondering what their next step should do.
Well, that's good that you know that you have it. I mean, it's unfortunate to have one, but so basically a long time ago in the 90s, when many people with TPS from El Salvador came to the United States, they might have had an interaction with immigration. They might have applied for an application and it got referred to court. And so I think a lot of people actually have in absentia orders and they don't know about it. Later, when TPS was opened up, they applied and they didn't know about the past, and so they got a new immigration A number. A person knows what their A number is. It's in different documents, but for example, on your work authorization card, it's listed A number, symbol, and then many people who got TPS in 2001, I think it starts with like a 95 or something like that. But if anybody had interaction with immigration beforehand, it would be an older number, which would be like a smaller number by a little bit. Now, when people renewed and they didn't know they had had an interaction with immigration before, they were issued a different number. And then now when they find out, they potentially could have 2 A files. So for this particular case, depending on how you found out that you had the innocence order, hopefully you did an immigration and EOIR, which is Executive Office of Immigration Review, Freedom of Information Act request, and found out that a notice was filed to whatever address you had given, and you want to try to find out what happened. So the first thing to do if you find out you have an in absentia order is do a FOIA. If you already did a FOIA, then have an immigration, and this is just an immigration court FOIA that I'm specifically talking about. There's FOIAs for lots of different agencies. And then if you have that FOIA, then have an experienced immigration attorney review it, because then you're going to be looking at the year it happened and to see whether or not you have a chance to reopen the case and if you have some other form of relief. So those are just the highlights of what you need to think about. But if you do have one and you want to change to some other status later on, like maybe your child's about to turn 21 in the next year or two, you need to be working on that now, because it can take a while to try to reopen a court case.
So someone just called in a question and they're asking that they met their wife in Germany. They're a U.S. citizen, and they got married to her in that country. And even though he couldn't travel there, is this marriage valid in the U.S.? And if so, is she his wife for immigration purposes?
So we revert to the Department of State's Foreign Affairs Manual, and they have a reciprocity chart that tells us what documents from different countries, who should be the issuer and where do they come from. But the simple answer to your question is, if it was legally binding and valid where it was officiated, then it will be for the United States purposes, for federal immigration purposes. And then another note is same-sex marriage in some countries was illegal and valid in those countries, but only until the last few years was it considered legal in the United States. But now same-sex or not same-sex, all different types of marriage. The one thing that the U.S. doesn't acknowledge is polygamy. So, but for the most part, for this question, as long as it was valid where you got married, it's good for the U.S. and for immigration purposes. And she is your wife for immigration purposes. But what the U.S. will do is to make sure you legally are married. In case you were ever married to someone before, you would have to show the divorce decrees with judge signatures and to make sure it's true and valid. Because I've seen many times where people have gotten married to people and they thought they were divorced to whoever they were married to before, but they weren't. So in general, yes, she's your wife for immigration purposes.
This next question states that they no longer live with their husband and that they are separated.
Mm-hmm.
She's asking if they are technically married since they never got an official divorce. And is it legal to allow him to come into the U.S. as her husband even though they are currently separated?
Okay, well that's a lot of different little issues there. If you're legally married, you're legally married. But for immigration purposes, so when people are separated, like they're doing counseling or having some issues, sometimes it's still a viable marriage. I mean, if people are trying. And so it could be a temporary little glitch there. But if you're legally married and you are not living together with the intention of being truly married, then immigration will consider that trying to obtain an immigration benefit for fraud. So now everybody has different definitions of what marriage is, and some people, even here in Houston, some people work offshore 1 month, 3 weeks, come back onshore 3 weeks, or some people live in different states and they're married. So that can be explained. But if you're separated and you're not really considering yourself married, then immigration won't consider yourself as a valid marriage for immigration purposes. And there's lots of different ways they look at, from leases to bank accounts and activity to taxes. what you call yourself out on taxes. So I would say that's my answer, but if you need any more clarification, you should get a consultation on that one.
This next question states that they are a U.S. citizen and 5 years ago they moved to Colombia to work as an engineer. They are living with their girlfriend at the time and eventually had a son, but never married their girlfriend. Now they are separating and want to bring their son to the U.S. with them, but they're afraid that the son will get denied a visa due to the fact that they are in Colombia.
Okay, well, first of all, the first thing you want to look at is if the son is already a U.S. citizen to begin with. Many people can be citizens of the United States and not know that they are U.S. citizens. So, depending on the year of birth of the child and depending on who was a U.S. citizen of their parents and if they were married or not, there's a chart that you look at and you have to prove whether or not the child is a U.S. citizen. So let's say you were to look at that chart. Now, there's some information missing here because for me to tell you the answer exactly, because I don't know when the child was born. But the one thing that makes it a little bit more complicated is because the couple was never married. And although the father, who's the U.S. citizen's name, is on the birth certificate, hopefully, that's one other question I would ask. Very likely, unless you weren't living with the child together, you would need to do a DNA test. There's a test for when the child is born out of wedlock, and it usually involves helping support the child, living with them, doing a DNA test, and other ways of acknowledging paternity. So let's say the child is a citizen. Well, then what you would do is you would go to the consulate and you would record the birth record abroad and get the certificate. The American would have to go and present the evidence to apply. And if you successfully meet that requirement, will get the certificate and you can apply for a U.S. passport. Okay, so let's say that would be the easiest thing to do in this situation. And I'm just talking about proof to enter. I'm not talking about custody or anything along those lines because that is not what we do here. We only do immigration. The other possibility is I guess maybe potentially the tourist visa, but some people think like that, and that's not really a good idea. Because, well, it depends on what you're trying to do. Because a tourist visa is for non-immigrant purposes, and you want the child to come to the United States. So then the other potential option is if the child is not a U.S. citizen and you cannot prove that they're a citizen, you could also apply for a green card for the child. And then once they come to the United States and live with you, who is a U.S. citizen, and they are under 18, they're living under your custody, and they enter as a green card holder, they can, depending on the year, but this looks like this is more recent, they would be eligible for automatic citizenship. So there's a couple scenarios here. Could be a little complicated, but it is possible. You definitely don't want to try to do this without some type of help.
So this next question is from someone that says that they have a friend in Angola, Africa. Her husband got a new job offer in Texas and wants to bring over their 2-year-old daughter that they adopted from Angola. Is the adoption going to be a problem for visa processes?
Well, if you have any idea you want to come to the U.S., you need to start talking to a family law attorney, and we could also discuss the immigration consequences or the possibilities. Basically, for adoption purposes, maybe you legally adopted, but you need to make sure it's compliant for immigration purposes. There's the Hague countries and the non-Hague countries. And so for immigration, they have strict rules. Generally, I would say it would be best to have a consultation about that to make sure everything was done properly. It could take a while for the immigration process to go through. I will tell you that it is common. It happened here in the United States in the 70s. Many people adopted children from like Russia and Korea and some other countries, and they didn't complete the process fully. And those children who are now in their like 30s are actually undocumented because the parents didn't finalize their citizenship process because they didn't understand how it worked. So for the children, I really strongly suggest making sure you have wise counsel, follow through everything, because it's not as simple as being able to just adopt and then that's your child, you can bring them in. You do have to meet some more requirements.
So the next question is about naturalization. I have had a green card now for 4 years and want to become a citizen. I don't have a criminal record and want to start as soon as possible. Is it true that I can begin 90 days before the 5-year mark?
So it depends on if, in general, yes. In general, yes. So if you received your green card based on marriage to a U.S. citizen and you live with them and you are still married to them, you can use the 3-year rule. If you get your green card or legal permanent residency from anything else, you use the 5-year rule. Now, there's lots of different requirements, such as being compliant with your taxes, not owing taxes, and if you do, you should have a payment plan that you can verify. Also, living the majority of your time in the United States, not having been gone for more than 1 year, or else that could break the continuous residence. So maybe that's not what you want to hear, but in general, you can apply 90 days before the 5-year mark. You also need to consider what language you're going to do the exam in. Some people need to wait longer if they don't speak English, and there's different qualifications for that where you just have to wait longer to meet those qualifications. But also you need to live in the jurisdiction that you're going to apply for 90 days before you apply. So, you know, the simple answer is yes, but the attorney answer is you have to look at the whole picture and make sure you meet the qualifications. And a lot of our clients have lived in foreign countries, I think with Houston being an international city. So we have a lot of questions about eligibility for naturalization, and we have to review all of their travels to see when they would be eligible, because that could delay the time when they're able to apply. Wow, so we've answered a lot of different questions that have been coming in throughout the week or online or from the phones. And, you know, we're doing this as a service to the community, give it a chance for you to get a question in. And we hope that you've enjoyed our program today between the updates and all these questions. That, I believe, is our last question for today. We have some other things to consider. We are going to do an asylum webinar on Wednesday, January 31st at 11 a.m. You can find out more on our website or our social media from Facebook and all those other things. So that will be me presenting on asylum on Wednesday, January 31st at 11 a.m. And it's free, and I'll be going over all the basics and some tips and trends. If you're interested in consultation, you can give us a call at 713-589-2085. And you can also, we do Skype and phone consultations because we understand not everybody can come to Houston, and that's fine. We can talk to you over Skype, phone, and even email or some other app if you really want to, and in person here in Houston, Texas. And let's see, we're going to have the webinar. This is how you can contact us. We also have a newsletter that goes out every other week, and we had one this week. And so you can sign up on our website at rubypowerslaw.com. That's Ruby, RUBYPOWERS, law.com. And there's a place down at the bottom right where you can sign up for the newsletter. And I think in general, we appreciate your time. If there's anything you'd like to hear us talk about or any questions, we'll collect them throughout the week, and you can also post them live. But, next week we'll be watching closely to find out more about the proposal by President Trump and see how Congress dissects and how they interpret that proposal, because this is key to keeping the government running. And so thank you so much. And again, my name is Ruby Powers. I'm a board certified immigration attorney with Powers Law Group, and hope you have a great weekend. Thanks.